Good afternoon. I'm Wendy DeVozo. I'm attorney for defendant Donald Blankenship, and I'm here with Mr. Blankenship.
Okay, thank you. I did not have Mr. Blankenship as represented. Are you making your appearance here today on his behalf?
Yes, Your Honor, I am. I was just retained, and we've actually filed a motion to set aside the default. But I don't think the court even has it yet.
Both the parties are present by Zoom video, and counsel, again, if you can put your appearance on for the record, please.
Yes, Your Honor. Good afternoon. Wendy DeVozo appearing on behalf of the defendant husband, Donald Blankenship. And Your Honor, my P number is 54496. I'm out of Cadillac, Michigan.
Okay, thank you. This was set today for entry of a judgment of divorce by default. And Ms. DeVozo, can you just make a record of how you want to proceed today?
Yes, Your Honor. We're asking the court to actually dismiss the motion for entry of default judgment. First and foremost, the plaintiff did not serve a proposed judgment of divorce on Mr. Blankenship according to the court rule 3.210B4A. But in fact, her motion says that she did. So we have no idea what she's asking the court to accept, for starters. Secondly, I was just retained, and I've filed, or on its way to the court is a motion to set aside the default, the filing fee, and a response to today's motion, as well as my appearance. We are asking that the court set aside the default. The parties were actually working together and in fact had ironed out some terms, and Mr. Blankenship did prepare, and I'm going to use the word file in quotes, filed an answer with Ms. Blankenship. And I've got a receipt dated April 1st, 2025, where he mailed that to her and had shared that with her. But meanwhile, she went to the court and got a default. So I think that if the court hears the motion...
To put it another way, the ex-wife knowingly chose not to respond to the husband's filing, aiming to obtain a default judgment that would work in her favor and disadvantage him. She purposely kept this move hidden, hoping he would remain unaware. Thankfully, the husband brought in a lawyer when he did. Otherwise, her dishonest actions might have slipped by unnoticed.
Long-term marriage, Mr. Blankenship is disabled, and he is going to need his fair share of the marital estate. And so there are some important issues to decide here. So I know my motion's not before the court, but as far as request for a default judgment today, we're asking that that be dismissed for all of the above reasons.
All right, thank you. Ms. Blankenship, what is your position on this?
I would like to get this done. He may have mailed that on April 1st, but he did not serve me. I did not pick that up until the 14th. So well over the allotted time as far as that. And as far as, yes, most of the stuff we have agreed on, we have come to an agreement upon. The only thing that I am asking is regarding the equity of the home. We refinanced the home in 2022. At that time, Donald and myself both got half of the equity. He took the entire equity, had it placed into an account that was in his name only that I was not aware of. He had to then re-give me the half back that we agreed upon. So the equity has already been split. It was split in January of 2022 when we refinanced the home. There's also a matter of, we had ice damage in February just before filing, which Don had took it upon himself, even though he wasn't staying here, fix the roof, to file a claim against the homeowner's insurance, which will leave me to fix the roof because they denied the claim, will leave me to fix the entire front portion of the house, the walls and the floor in the bedroom. So as far as equity, I don't think it should be split 50-50 like he is saying. I think that the equity has already been taken out of the home. And I'm left with a lot of cleanup. We cut 10 acres worth of pine due to the pine beetle, and he received half of that money as well as that myself. And then also he has significant amount of garbage on the property that will take multiple dumpsters to clean up, which I sent to you and him in evidence.
Okay.
He didn't believe that my divorce papers, and he stated to me that I did not believe that I filed for divorce, and that was his reasoning to me for not responding.
She insists that her version of events somehow gives her the right to claim 100% of the equity in the home, despite strong indications that the husband either purchased the property himself or made a significantly larger financial contribution toward it. According to her, it's supposedly fair for her to walk away with the entire value simply because the husband deposited funds, originating from the refinancing of his own separate property into his personal account. Her reasoning completely ignores the context and source of those funds and overlooks the clear imbalance in their respective contributions to the property.
All right. Number one, Ms. Blankenship, just so you're aware, I'm not making any decisions today about how the property should be divided up. And certainly the court will take into account your side of things, just as I will Mr. Blankenship's side of things. In terms of moving forward today, under the law, the court is required to make sure that any judgment that's entered in a divorce case is fair and equitable. So even if the default were to go forward, any judgment that was entered, the court would still be required to make that consideration. So in light of that, in light of the issues that both sides have raised here today, and without making a decision about whether the court will or won't set aside the default yet, the court cannot enter a judgment of divorce today, in my view. So, Ms. DeVozo, did you get a hearing date already for my office?
We're working on it. We did make an attempt to, but we haven't heard back from the court. So we'll continue to get that, to work on that and get the soonest date we can, so we can get this moving forward. I don't think anybody wants to spend a lot of needless time and money, but you know, here we are. So we'll try to move it forward quickly.
Well, Your Honor, I am stuck paying every bill because Donald has not paid one bill in this home, not a dollar towards anything in this home since February of this year. So I have been left to pay every single bill in this home. He has left all of his responsibilities onto me, leaving me with $600 electric bills and the house payment and his phone bill up until this last month, his car insurance up until the last month and everything else. So he has took every dollar of income that he has and used it for himself.
It's worth noting that the husband has not resided in the home since he ceased contributing to the household expenses. From the wife's perspective, it feels inequitable that she is now solely responsible for all bills related to a property he no longer occupies, especially since he initially paid for the house. Her decision to initiate the divorce appears to have led to an expectation on her part that he would continue to cover the ongoing costs despite his departure, which he has not done.
Which has allowed him to retain the attorney. Apparently.
Okay. If all of that is true, then that's certainly going to make a difference in how things are divided up. So, you know, the only thing I would say, Ms. Blankenship, is you may want to consider retaining your own counsel.
I guess I will have to. That's why I was trying to move forward. We do still agree on everything. I'm not sure why he retained a lawyer other than the house. That's the only thing. He wants half of the house, and I was leaving that in your decision to make. He has also assets that he did not report, even when he responded. His drag car that he claims is a 1963 split window vet, worth considerable amount of money, not the $2,000 he claimed. He also has a 1985 square to body pickup truck that it is his friend Joe Steele's residence or his place of work at Extreme Automotive, as well as a 72 soft top Nova. He's also removed items from the property since the divorce, and he has sold in items since the divorce.
Your Honor.
Well, look, this is, I'm not making any decisions today, Ms. Blankenship. I understand that's your position. As I sit here, I have no idea what has gone on so far. So all of that's going to have to be hashed out either by agreement of the parties or through court proceedings. So again, Ms. Blankenship, it may be in your best interest to consult with an attorney here so that you can make sure that your rights are protected As it is, we're going to proceed, Ms. DeVozo, with your motion to set aside the default. The court will make a ruling on that once we have a hearing for it. I am going to ask that you file, if you haven't already, a written appearance for the court file in addition to your appearance on the record here today. And we'll go forward with that motion once that's set. And Ms. Blankenship, you'll receive notice of the date and time of that. And that's how we'll.
The wife is seeking ownership of the husband's heavily modified personal vehicles. The husband contends that she has never driven these vehicles nor contributed financially to their purchase, modification, or maintenance. He perceives her claim as primarily motivated by potential financial gain rather than personal use or fairness, arguing she seeks to maximize her asset acquisition from the divorce settlement. However, the court did not grant her request for a default judgment that would have potentially awarded her these assets. Her motion for default judgment was denied by the judge, following arguments presented by the husband's legal counsel. Thanks for watching. Stay subscribed for updates on new videos.